Senators in here waiting. Okay, good afternoon. Today is March 26th, and this is the bill hearing of the Ways and Means Committee. We're going to go ahead and get started. Thank you. If you were supposed to come here yesterday, we appreciate it. We were in a 7-hour budget debate yesterday, so we appreciate you coming today. For Senator Benson, Stephen Eskew, yeah, come on up, please. Senate Bill 130.
Good afternoon, Chair Atterbury, Vice Chair Wilkins, and esteemed committee members. My name is Stephen Askew. I'm giving this testimony on behalf of Senator Joanne C. Benson. As a legislator of District 24 and a retired educator of Prince George's County Schools, I am deeply committed to fostering a supportive and effective learning environment for our students. Today, I support the proposed legislation to ban cell phones in schools. This legislation's primary goal is to enhance our students' academic focus, mental health, and overall safety by reducing the distractions and potential harm associated with cell phone use during school hours. Please allow me to explain why this legislation is needed. Reducing distractions. Cell phones are a significant source of distraction in the classroom. By limiting their use, we can help students concentrate better on their studies and improve their academic performance. Supporting teachers. Teachers often struggle to maintain students' attention when cell phones are present. This legislation will empower educators to create a more focused and engaging learning environment. Reducing anxiety and depression. Research has shown that excessive cell phone use, particularly on social media, can contribute to increased anxiety and depression among students. By limiting access during school hours, we can help mitigate these mental health issues. Encouraging social interaction. Reducing cell phone use encourages students to engage with their peers and develop essential social skills. Minimizing online harassment. Cell phones can be used for cyberbullying, which can have severe emotional and psychological effects on students. A ban can help reduce these incidents and create a safer school environment. Reducing cheating. Cell phones can be used to cheat on exams and assignments. Banning them helps maintain academic integrity. Managing emergencies. While some parents may worry about being unable to contact their children, schools can implement policies that allow emergency communication without disrupting the learning environment. Here's a personal story. As a retired principal and educator, I have always been committed to ensuring the highest education standards in our schools. My involvement with the Prince George's County Public Schools District 24 has allowed me to hear firsthand the concerns of teachers and parents about the impact of cell phones in the classroom. For instance, during a recent discussion, a middle school teacher expressed frustration about the constant distractions caused by students using their cell phones during class. She highlighted that students often engage in non-educational activities such as texting, gaming, and browsing social media, significantly disrupting their learning process and hindering the overall classroom environment. Additionally, a concerned parent shared that her school's academic performance has declined due to excessive phone use during school hours, resulting in decreased attention to lessons and assignments. These examples underscore the urgent need for policies that effectively address the use of cell phones in schools to ensure that our students can focus on their education and reach their full potential. Research and data. Studies have consistently shown that limiting cell phone use in schools leads to better academic outcomes and improved mental health. For instance, a study by Anna Lamb, Harvard Gazette staff writer, March 2023, stated, in 2020, the National Center for Education Statistics reported that 77% of U.S. schools have moved to prohibit cell phones for non-academic purposes. Other states and districts such as Florida, Louisiana, and South Carolina have successfully implemented similar statewide restrictions with positive results. Their experiences can serve as a model for our efforts. Finally, the proposed cell phone ban legislation is a crucial step towards a more focused, healthy, and safe learning environment for our students. Therefore, I urge your favorable vote to support this legislation and help us build a brighter future for our children. Thank you for your time and consideration.
Thank you. Are there any questions? Okay, seeing none, thank you very much.
Thank you.
That concludes the hearing on Senate Bill 130. Senator Kramer, Senate Bill 93.
Madam Chair, I do want to let you know I was not the first one here amongst my colleagues, but I mean, if you're ready for me, I'm ready to roll.
I'm just going down my list.
Perfect. All righty then. Well, good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Ben Kramer here introducing Senate Bill 93. Colleagues, a few years ago, the good vice chair of this committee and I sponsored legislation that proved to be incredibly successful. And it allowed for an application for an absentee ballot to be mailed to registered voters in the state. And as we saw in the past several elections, voter participation soared, particularly with voters voting by mail. So the goal was to ensure that we do everything possible to give every resident the opportunity to participate in our great democracy and to vote, and particularly our elderly and our residents with disabilities who may be challenged getting to the polls. But unfortunately, the bill had a sunset provision, and the last election that the process for doing this has passed. So this is a companion bill to House Bill 201, the Vice Chair's legislation. And as it came in, it would have simply continued, as introduced, the bill would have simply continued the very successful process that we have been experiencing. Having said that, the committee with jurisdiction on the Senate side kind of tortured the bill. And as it is before you, Madam Chair and members of the committee, the bill now simply provides that a local board shall send a written notice regarding a request for state-approved absentee ballot application with the specimen ballots that they send out at election time. So it's going to be a very, very different process, my guess is. It will not be nearly as successful as what we experienced the last few elections in increasing participation in the election process. But that is the way the bill is before you all at the moment. And with that, Madam Chair, happy to take any questions.
Okay, are there any questions from the committee? Okay, thank you very much.
Thank you, Madam Chair. Committee, enjoy your afternoon.
Thank you. That concludes the hearing on Senate Bill 93. Senate Bill 313, Senator Washington.
Thank you, Madam Chair, Adebayo, Vice Chair Wilkins, and gang. I know you're not at all familiar with this bill, which establishes risk-limiting audits in Maryland. Oh, for the record, I'm Senator Mary Washington. This is the cross-file of a bill that you passed unanimously, and I believe is on a consent calendar on our side. Just for the record, for those of you who don't know, risk-limiting audits are the gold standard for election security. It clarifies roles, it provides local flexibility, and assures accountability. So, gratefully and finally, I asked for your favorable report on Senate Bill 313. Any questions?
Okay, any questions from the committee?
Definitely
thank
these
you very
days already.
much.
Thank you so much, Madam Chair.
That concludes the hearing on Senate Bill 313. Senate Bill 472, Senator Rosa Pepp.
Thank you, Madam Chair. It's good to be back in Ways and Means, where I served for 11 years when I was in the House. It's always good to be with you, and I appreciate all your work with us. So this is a fairly straightforward bill. For years, municipalities have had the ability to set differential tax rates on different kinds of property. And there's a few cases where counties can. But what this bill is focused on is trying to promote development around transit stations. And so basically it allows Baltimore City and the counties to set a differential rate on undeveloped land within 1 mile of a transit stop. So undeveloped land could be set at one rate and developed property at another rate. The idea is they could use that tool in a flexible way to try to promote development that the county wants to encourage. That's the bill. Happy to answer questions.
Okay, any questions from the committee? Okay, thank you very much.
Thank you.
That concludes the hearing on Senate Bill 472. Senator Jennings, Senate Bill 488.
Thank you, Madam Chair. Senator Jennings, for the record, Senate Bill 488. This is a direct cross-file of House Bill 168. This bill is amended out of the Senate, and what it does is it takes away from the authorization, makes this basically allows for this exemption. What it does, it pushes for, it promotes manufacturing in our municipalities and our counties, trying to bring in small business. And as amended, it basically allows these governing bodies of municipalities or counties to allow small and medium-sized manufacturing enterprises from paying personal property taxes on their equipment or their inventory across Maryland. Again, it gives these counties and these municipalities the ability to push this forward if they choose. It's up to them. The reason this is going forward is trying to take away some of the confusion on whether or not these counties or municipalities can do this. So it's just trying to promote manufacturing in throughout our state and bring business and jobs to our state. So with that, I ask for a favorable consideration.
Okay, any questions? Okay, seeing none, thank you very much.
Thanks.
That concludes the hearing on Senate Bill 488. Senator Hershey, Senate Bill 774.
Thank you very much, Madam Chair, members of the committee. For the record, Senator Steve Hershey to present Senate Bill 744, which alters the assessment process used by the State Department of Assessment and Taxation when evaluating operating property of a rural broadband service provider. This is in the same posture as House Bill 969 that passed unanimously out of this committee, and it does have the MACO requested amendments. I ask for a favorable committee report.
Okay, any questions for Senator Hershey? Okay, thank you very much.
Thank you very much.
All right, that concludes the hearing on Senate Bill 550. Senator Attar, welcome back to Ways and Means.
Thank you, Madam Chair, Madam Vice Chair, and it's so nice being back. I miss you all a lot. I'm here for Senate Bill 911, which is an exact cross-file of House Bill 910, which a couple of weeks ago you guys passed out of this committee unanimously, and this bill just increases the tax exemption for blind individuals from $15,000 to $40,000, so I ask for a favorable report.
Okay, any questions? Okay, thank you very
Thank
much.
you.
We'll give you an applause on your way out.
Thank you, thank you.
That concludes the hearing on Senate Bill 911. Senator Reedy, Carroll County, Senate Bill 885.
Thank you, Madam Chair. It's great to see you and all of the friends here in the Ways and Means Committee. I'm here to present Senate Bill 885, which deals with vacancy procedures with the Carroll County Board of Education. It's identical, should be identical in form to what passed HB 1118, which passed out of here, and out of the House and over to the Senate. Just allows for the filling of vacancies in the Carroll County Board of Education by a vote of the Carroll County Commissioners, and also provides for some special election possibility if it happens before a certain point in the 4-year term, kind of mirroring some of what's been discussed about other vacancies. So with that, Madam Chair, I would ask for your support, and thank you very much. Happy to answer any questions.
Okay, any questions? Okay, thank you very much.
Thank you.
That concludes the hearing on Senate Bill 885. Senator Brooks, the Senator Brooks Show.
Okay.
Whichever one you want to start with, you have 3.
Okay, Madam Chair, I'll start with 601.
Okay.
Okay, good. And no, I didn't make the wrong turn. Yes, it's nice to come back over, and no, I'm not trying to obtain squatters' rights. So, okay. Chair Atterbury, Vice Chair Wilkins, and members of Ways and Means Committee, thank you for the opportunity to testify before you on Senate Bill 601 as the Education Children of Service Members Advanced Enrollment Procedures. This legislation provides much-needed support for families of our nation's service members by ensuring that the children of active duty member military personnel have seamless access to public education when their families are relocated to Maryland due to military orders. Okay, SB 601 is a cross-file of HB 596, which passed out of this committee in a slightly different posture, and I'd like to highlight the 3 main differences. The one is transferring IEPs, that's individualized education programs. Although SB 601 and HB 596 both seek to ensure that children with disabilities experience no delay in receiving the appropriate educational services when moving to Maryland, they achieve this goal in a slightly different way. HB 596 explicitly cites that IEPs and 504 plans and outlines a remote registration mechanism that allows parents to indicate these plans during enrollment. Meanwhile, SB 601 uses a broader language referencing special education and services upon the free, appropriate public education standards, which inherently includes a service outlined by IEPs and 504 plans. Despite this less explicit approach, SB 601 still requires prompt coordination between local schools, parents, or guardians, and sending the state schools district to prevent service disruption, effectively covering the same ground as HB 596, albeit with more generalized language. Now, disenrolling after changing residency. Under HB 596, a dependent student of a service member will no longer meet a school residence requirement and can remain enrolled only until the end of that particular school year. Preserving the superintendent's authority to determine future replacement. In contrast, SB 601 would permit that child to continue attending the school through the completion of the highest grade level available, subject to a case-by-case review. While HB 596 focuses on limiting the student's eligibility to stay once residency changes, SB 601 offers more flexibility and continuity for military families by allowing the child to remain at that same school over multiple years. At the same time, SB 601 preserves districts' oversight by requiring local system to review each situation individually, which can be viewed as a more comprehensive approach in supporting the educational stability of service member children. A great example of this would be a school junior, allowing that student to stay and attend for their senior year and graduate with their peers. And the last one would be qualifying for advanced courses and extracurricular. SB 601 explicitly requires local school systems to prioritize continuity in education for a dependent child of a service member and grant that child access to all courses and programs for which they qualify, including extracurricular activities through advanced enrollment. This approach ensures that military dependents can enroll in higher level classes or activities remotely, rather than being forced to show up in person before the family has relocated. In contrast, the House new language in HB 596 states that such students would enroll in the same manner as others, which effectively reintroduces the very gap that this bill aims to close. The Public School Superintendent Association only sought to clarify that advanced enrolling students should access all courses or programs that they qualify for, rather than having them to meet in-person enrollment procedures before starting those classes. We believe the intent of HB 596 is well in line with SB 601. However, we respectfully ask that the committee pass SB 601 in its current posture and align HB 596 to conform with SB 601 in order to fix this particular oversight. And thank you, and I'll entertain any questions on this one.
Okay, are there any questions from the committee? Okay, seeing none, that concludes the hearing on Senate Bill 601. Which would you like to do next?
Let's go to SB 602.
Okay.
Okay, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means. Thank you for the opportunity to testify before you on SB 601 as the County Board of Education Special Education Service Delivery Models. Publication requirements. This bill strengthens transparency for Maryland students while also clarifying obligations and practices regarding the provisions of special education services to students in both public and private schools. This is the cross-file to HB 702, a bill that passed out of this committee and which passed out of the full House unanimously. SB 601 is in the same posture. And I urge a favorable report.
Okay, any questions from the committee? Okay, seeing none, thank you. That concludes the hearing on Senate Bill 602. And your last one, Senate Bill 929.
Yes. Chair Atterbury, Vice Chair Wilkins, and members of this committee, thank you for the opportunity to testify before you on SB 929 as a work group on mail-in ballot accessibility. The purpose of this bill is to enhance accessibility and equity in Maryland's voting process by establishing a work group dedicated to examining and improving mail-in ballot accessibility, particularly for voters with disabilities. This initiative aims to ensure that all voters, regardless of their physical abilities, have the opportunity to participate fully and independently in the democratic process. SB 929, as amended, ensures a balanced work group by including in its membership representatives from disability community, cybersecurity, IT, election officials, and experts, and require consultation with federal partners in relations to its work. This is a cross-file of HB 1097, which has not yet been voted upon by this esteemed committee, but we're hoping that it will. And there, in case you need it, there is a notation that this measure, SB 929, would ignore risk and which would inevitably green light electronic ballot returns in Maryland. But I was confused when I read that because this bill does not mention work electronic ballots once. It does not. What it does is it's a work group, and the work group will determine which methods are better for evaluating the ballots, and then it would make recommendations. So, and for this, I request a favorable report.
Okay, are there any questions from the committee? Okay, seeing none, thank you.
Thank you, Chair.
That concludes the hearing on Senate Bill 929. Senator Hedelman.
Thank you very much, Madam Chair. I think I have a couple before you today,
Yes.
so what would you like to do?
You want to do 327?
Sure.
Okay.
Senate Bill 327 is the exact cross-file as amended as House Bill 390. They are in the same position. It is, sorry, for the record, my name is Shelley Heddleman. I'm Senator from District 11 in Baltimore County. I'm very happy to be here with you today, trying to be in many places at once. So forgive me for the lack of introduction. Senate Bill 327 is the exact cross-file of House Bill 390, which was sponsored by Delegate Corman. I believe they are in the same posture. They were amended in the exact same way, and this is to provide and address an issue in some of our counties with the development of affordable housing and using pilots to do so. This is a way of, especially with regard to older housing stock, to give a little more flexibility to our local governments to be able to preserve that and maintain it as affordable housing. I ask that you respond favorably to this bill.
Okay, are there any questions from the committee? Okay, seeing none, that concludes the hearing on Senate Bill 327. Senate Bill 598, Senator Heddleman.
Thank you very much. For the record, I'm Shelley Heddleman, Senator from District 11, and I'm here to present Senate Bill 598, which is the exact cross-file of House Bill 585 and a member of your committee, Delegate Polakovich-Carr. And these two bills are also in the same posture, and it has to do with creating better communication with the developers of affordable housing and SDAT, and making sure that valuations are done correctly. And the way the bill is amended, that we notify within 30 days of closing, that the DHCD will notify SDAT that a property's been awarded a low-income housing tax credit. Without further ado, I'm happy to answer any questions and ask that you report it out favorably.
Okay, any questions? Okay, seeing none, thank you. That concludes the hearing on Senate Bill 327. Senator Heddleman, I'm sorry, that was 598. Senate Bill 845, and you do have one witness, Jonah Spiegelman.
I didn't even realize that. Wonderful. Terrific. That is lovely. My name is Shelley Heddleman. I'm Senator from District 11, and I'm happy to present to you today Senate Bill 845. This bill was cross-filed with, you will forgive me, I don't have the House bill number, but Delegate Moon. It did not make it out in time, but I want to tell you a little bit about this bill, and we scrambled on the Senate side to amend it and to get it out before crossover. And I think it's a very good bill. This bill will provide local education agencies with an additional tool in their hiring process and in vetting. And I will tell you a little bit of the backstory and the reason for this bill. Many of you may have read a little over a year ago, I believe it was a year ago, January, Pikesville High School, which happens to be my alma mater, and Jonah is a current senior at Pikesville. The principal there suffered quite an indignity when the athletic director used AI to impersonate his voice and said quite racist, anti-Semitic things. The principal was, there was an investigation. There's legal action now involved. Long story short, and I included a copy of an article from the Banner that really goes through kind of what tools might have been implemented to perhaps raise some red flags in the hiring of this teacher, the athletic director. It turns out that there were some administrative things that had happened in his history that if this school system perhaps had used a screening agency, and there is a national nonprofit that does so right now, that now Baltimore County and MSDE and a few other local education agencies are members of, that they may have picked this up in this individual's history prior to offering him a job. So what the bill would do is it would enable MSDE on behalf of all of our 24 local jurisdictions to be a member, to pay, I think it's just over $23,000 to become a member of such a clearinghouse, and that would enable each LEA to use their services. And so at the front end of the process, they would be able to put a name, have this potential hire vetted by this agency to see if there have been red flags and administrative actions in other parts of the country. For example, if somebody is coming from another state and trying to come here. So this just adds another layer of vetting in a very inexpensive way to the hiring process. MSDE uses it now, but that is much further down in the process, and this way, this small investment can enable local jurisdictions to do so at the front end of the process. It's not an automatic, no, we don't want to hire this person, but it is a, hey, we need to dig a little deeper and find out what is going on here. So that is the reason for the bill, and I think we have done it in a very descriptive way so as not to name a particular agency, but to outline the quality and services that must be provided in the course of this vetting. So I'm happy to answer any questions that you may have.
Do you want to go ahead for, you want to
I can
testify?
go ahead.
Okay, yeah, for 2 minutes, please.
Good afternoon, excuse me, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee. My name is Jonas Spiegelman. I'm a senior at Pikesville High School in Baltimore County. I'm here today to respectfully request a favorable report on Senate Bill 845. As Senator Hedelman said, the bill was introduced because of events that took place at my school last year, and I'm here today to tell you my experience with what occurred and how this bill will prevent anything similar in the future. As Pikesville's mascot, I've become very close with my principal as we planned dozens of events starting early in my freshman year. By winter of 2024, I had a very strong relationship with him. We frequently talked in the hallway about school stuff or sports or anything else. However, on January 15th of 2024, I was woken up around midnight to a flurry of messages from classmates asking if I had heard it. Initially, I didn't know what the "it" was, but someone sent me a video, a 45-second audio clip that sounded like my principal going on a racist, homophobic, and anti-Semitic rant about students, staff, and community members. I was blown away thinking that someone I knew would say things like this. The school was shook. The principal was removed, and I came to school hours later to a dozen news stations covering the event. It took until late April until we learned that our school's athletic director was accused of creating the audio clip with AI, and he was arrested. While my principal got a new job, his reputation had been irreversibly tarnished because of the actions of the athletic director. He should never have been hired in the first place. It was proven that he lied on his job application about past experiences, and it was reported that he was flagged by the organization that this bill would establish in every county in Maryland. The passing of this bill will give school systems throughout the state another tool to screen potential future educators who should never get through the vetting process. Accordingly, I respectfully encourage a favorable report on Senate Bill 845 from this committee. Thank you.
Thank you. Thanks for taking the time to come down and testify today. Questions? Delegate Fair.
Thank you, Madam Chair, and thank you so much for bringing the bill forward. This came to our subcommittee, and Delegates Miller, Hornberger, Eversole, and I kind of worked together. Ironically, a lot of the edits, we must have been working out of the same brain because we were making the exact same changes to the bill that were brought forward here. But I really want to drill in on exactly, this is where we got hung up as we were having our discussion about how to amend the bill and really what was it targeting. The current MSDE process has a full screening for employment background checks on all of these employees. That was obviously our largest concern, was whether or not we were properly screening employees for criminal history and especially history of any criminality towards children or anything like that. And we did not, we found out that whole background check system is already done. This would add an extra layer. I just couldn't quite drill in, and I think that your testimony touched on it slightly, but I was wondering if you could help us understand what these administrative background checks are really kind of driving to discover.
Sure.
Thank you.
I'll just give you an example. I mean, like fraudulent, here, wait a minute, let me see if I can. So there was an incident, I'll just refer to this one particular case, although there are many. When he left a Florida school in October of 2015, the records show he resigned from his job, I'm just reading from the article here, as a paraprofessional, a kind of assistant teacher at a high school in St. Petersburg after administrators confronted him about texting a female student. And then they include some of the details about that. And the Florida school district determined that that person was not eligible to be rehired. Like that would have been the kind of thing that the county might have, that would have been reported to this clearinghouse, that the county would have said, we need to drill into this a little more and get some more information.
And that is not currently getting picked up by the current background checks that are required?
No, because what you're talking about, and which is 1,000% support, are things that are criminal, are things that are in official legal records. And that is not what this is after.
Thank you. Thank you so much, Senator. Thank you, Madam Chair.
Delegate Ebersol, you're good, okay. Oop, any questions? Okay, thank you very much.
Thank you so much.
That concludes the hearing on Senate Bill 845. Senator Sailing, Senate Bill 352.
Good job.
Thank you, Madam Chair, Vice Chair, and Committee. For the record, Senator John R. Sailing, and talking about Senate Bill 352, also is cross-filed. And I want to thank the committee for hearing me out. This bill first was a sponsored bill, and now it changed. And I want to thank the good Delegate Ebersol, helping me out and communicating with me kindly. We wanted to make sure that this bill and the changes that were happening now in Baltimore County, we are now going from 7 to 9 councilmatic districts. And so we needed to make changes in the Republican Party. So again, I want to thank the good delegate working with us and now adding just this as a Baltimore County bill and not a sponsored delegate or senator bill. And we were able to work it out in a way with the amendments, the changes for the central committees of the Republican and Democratic Party. And that's pretty much the bill. And if you have any questions, I'm more than happy to answer.
Okay, thank you. Delegate Ebersol.
Because you said it, we make sure the amendments that we attached to ours when we sent it over to you would be the same ones you'd be willing to go with here, since it was just some house cleaning for the Democratic Central Committee.
I want to thank you, and yes, sir.
Cheers.
Okay, seeing no further questions, thank you very much.
Thank you, and have a fantabulous day.
You too. Senator Simon Ayer. You have a couple bills. Let's start with Senate Bill 276.
Thank you. It's great to be before you. Senator Simon Ayer for Senate Bill 276. This is identical to Delegate Patterson's House Bill 600 as passed by the committee. I would ask for your favorable consideration. It's identical to their bill.
Okay, any questions? Okay, that concludes the hearing on Senate Bill 276. Senate Bill 308, Senator Simon Ayer. I should say, I'm looking it up now, but there's one person here to testify. If you know who it is, you can go ahead and call it, but, oh, it's Jared. Come on up, Jared. Okay.
You always get that reaction?
Right, exactly.
Thank you. For the record, Senator Simon Ayer presenting Senate Bill 308, party affiliation of chief judge, election judges. First, I want to thank the Board of Election and Mayo for working with me on this legislation. So first, let me tell you about the problem. First, current law does not require chief judges to be of different parties, only the total number of judges. As you know, chief judges supervise all the precinct judges and are in charge. Second, getting volunteers at each precinct to have equal number of election judges from the majority and principal minority parties can be challenging, if not almost impossible, especially in deep blue or red precincts. Therefore, this bill, one, strengthens our elections by requiring both precinct election judges to be from different political parties to the extent practical. And if it's not possible,
Then it requires one must be of the majority or minority party, and the other be someone not of the majority or principal minority party. Example, an unaffiliated judge. Third, it ensures Maryland won't have two judges, chief judges from the same party at a precinct. And it also requires that other election judges working under the chief judges have an equal number of judges from both the majority and principal minority party to the extent practical. When not possible, current law allows unaffiliated and other voters to become election judges. So in summary, this is consensus legislation, no fiscal impact, and no opposition, and I would ask for your favorable consideration.
Okay, you just for questions or?
Yes, yes.
Okay, any questions? Okay, well, there are no questions. All right, that concludes the hearing on Senate Bill 308, Senate Bill 310, and there's someone, let's see if their virtual person is here, but you can go ahead and get started.
Okay, thank you. On the last bill, Senate Bill 310, this updates the Maryland Youth Suicide Prevention School Program. This bill does two things. It aligns the Youth Suicide Prevention Program with the blueprints language. And secondly, it increases the awareness guidelines to include gambling addiction that can contribute to youth suicide. I worked to bring this consensus legislation to the committee. It has no mandates, no fiscal impact, and no opposition. And respecting the committee's time, we put most of the support in the folder instead of bringing people here. So take a look at it. But I did want to highlight the broad support from the stakeholders. We have from the Department of Health to education to medical to mental health and even casino operators. And also, while we work hard, sometimes we don't get to know each other personally because we're so engaged in our legislation. So I wanted to share why this was a passion of mine. My dad and I would occasionally go out to Las Vegas. He lived in Arizona, and we would do blackjack. He loved slots. But when they brought gambling to Arizona, it was much more accessible, and he started to get addicted to it. And he ended up losing $1 million, and a couple years ago died broke. To add on to that, my grandfather from my mother's side got into gambling, and with the shame and loss of money, he actually committed suicide. So what I've been trying to do, again, I'm not against gambling, but trying to get prevention opposed to helping people with millions and millions of dollars after they get addicted. So last year, the General Assembly helped me pass the Maryland Veteran Suicide Prevention Bill dealing with veterans. And suicide is tragic no matter whose life is lost, whether it's a veteran, a neighbor, or a student. And in Maryland, we created the Maryland Youth Suicide Prevention School Program to provide guidance on suicide and various influences that lead to it. So this bill updates the program, which hasn't been updated since 1996, and brings into the 21st century. So more than 10 years ago, this program was established. The people of Maryland approved casino slot machines. A lot has happened since then. We've had table games, more sites, more ways to gamble, and we brought in a lot of revenue to help our state. Additionally, more than 15 years after this section was last revised, the Blueprint for Maryland Future was passed with insight into youth suicide. However, the legislature hasn't updated this program in some time. We're in the perfect storm for trouble for our youth. We have suicide among our youth being too high, and we have gambling becoming more and more accessible every year. There are studies showing gambling addiction can lead to youth suicide with increased pressures. We are also seeing that youth adults ages 18 to 25 are the most likely age group to become addicted to gambling. That's our high school graduates. When I joined the General Assembly, we had lottery and horse racing. Today, we have expanded gambling all across the state to include sports betting, even from our couches. This bill is not mandating, but it's a small step to bring more awareness and recognition of the potential issues of youth gambling and suicide. When it comes to gambling addiction, I believe prevention is so much better for Marylanders than the millions in treatment for an addiction after it's created. So in summary, this is consensus legislation where I brought all the parties together, no fiscal impact, no opposition, and broad support, and I would ask for your favorable consideration.
Okay, thank you. We have Anna Cagle, please, for 2 minutes.
Good afternoon, Chair Atterbury and members of the committee. My name is Anna Kate Cagle, a student attorney with the University of Maryland Public Health Law Clinic, testifying today in support of Senate Bill 310. Although people often underestimate the risk of gambling, it can be just as dangerous, if not more dangerous, than other addictions. Similar to other addictions, gambling can lead to adverse consequences, including psychological distress, strained relationships, and poor academic and work performance. What sets gambling apart, however, is that it has the highest suicide rate of any addiction. Approximately 50% of gamblers experience suicidal ideation, and 20% in treatment for gambling disorder attempt suicide. Gambling is even riskier for adolescents than adults. Studies estimate that adolescents are 4 times more likely than adults to develop a gambling addiction, and the younger someone starts gambling, the more at risk they are of these harms. This is particularly alarming because the average age a child first gambles is only 12 years old. This is earlier than the average age of first use of alcohol, tobacco, or any other drug. In 2022, approximately 17% of Maryland high schoolers reported gambling on a sports game, the internet, or while playing a game of cards, dice, or video games. Because youth are vulnerable to the harms of gambling and often underestimate the risk of this behavior, it is critical that adolescents are being educated about the potential harms of gambling at a young age. Education has been proven to be an effective tool to improve the knowledge of the harms of gambling and reduce the frequency and severity of gambling among participants. Therefore, Senate Bill 310, which amends an existing program to encourage schools to educate students on the relationship between gambling and youth suicide, is a crucial first step to ensuring Maryland students receive the information they need to make informed choices and ultimately to prevent the development of problem gambling and its deadly consequences. For these reasons, I urge a favorable report on Senate Bill 310. Thank you.
Thank you. Any questions for Senator Simonaire or Ms. Cagle? Yep. Delegate Hornberger.
Yeah, this is an incredibly serious issue, and although the bill doesn't speak to what the curriculum would look like, and this is something that I've studied, there is a school of thought out there that says that suicide rates can increase once there is heightened awareness about suicide. So I didn't know if you or the person who testified on the bill was aware of that school of thought, but there is that school of thought. So what would the curriculum look like? And is there proof out there that this type of curriculum would lead to decreases in suicide?
Well, thank you for the question. So this is not mandating any curriculum.
Okay.
That's how we got consensus with this. This is guidelines, and then the department would work together, and it's optional. It says they may include, and they list certain things. So that would be the Department of Education, and with all their wisdom, how to put it together, how they wanted to do it. So this does not mandate it.
Okay, great. Okay, and then did the person testifying on the bill virtually want to weigh in on that?
Sure. So this is also an already existing program. So currently schools have the option to teach their kids about the relationship between suicide and substance abuse and things of that nature. So this just essentially adds in gambling to that program. So as far as your concerns about the suicide risk,
it's referred to as suicide contagion.
Right. Yes, but I see that that's a concern. However, there's always going to be a concern when you're educating children about a serious issue that certain kids can then learn from that. So they learn to do that behavior from from the program. So here it would be learning about gambling, starting to do gambling. However, because of weighing the risk here, and that so many kids are exposed to gambling, are gambling, and how severe and significant the risk of suicide is against that, compared to the risk of suicide just from what you're talking about, the suicide contagion. So that's such a smaller risk versus what's already happening. So this is a quite necessary intervention program.
Okay, thank you. Thank you, Madam Chair.
Okay, any other questions? Okay, thank you very much, Senator Simonaire. Thank you, Ms. Cagle. That concludes the hearing on Senate Bill 310. Senator Kagan. And whichever. order you want to go in, it's fine with me.
Oh, that's awfully nice. Thank you, Madam Chair. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. I have 6 bills, and I will say that 4 of them are identical. So if it's okay, I'll just do those first really fast. The first one, Senate Bill 337, is about taking the transparency laws that we have enacted over the years, Delegate Corman and me, and not only that the state Board of Elections, but all of our local boards would stream their meetings and post their meeting materials and agendas. It has passed both bodies. Happy to take any questions.
Any questions? Okay, that concludes the hearing on Senate Bill 337. Senator Kagan.
Next bill, let's do my own delegate, wonderful Polakovich Carr, Senate Bill 633, scam packs. We have both passed that bill, and it just will help provide greater transparency as recommended by the Federal Bureau of Investigation, the FBI, and the Federal Election Commission to make sure that our consumers, our constituents, don't get ripped off by phony baloney causes. Happy to take any questions.
What number was 630? Okay, thank you. Any questions? Okay, that concludes the hearing on Senate Bill 633. Senator Kagan.
Thank you, Madam Chair. Next up, let's do Senate Bill 645, which I cross-filed with the wonderful Vice Chair Wilkins, and that just moves the next year's primary election up 1 week, so we make it easier to have early voting centers, have more judges, have everybody still in town before school renovations and stuff get started. Happy to take any questions. The next one, Senate Bill 543 with Delegate Roberson. And this would allow ballots that would be normally rejected from the provisional ballots if they cast a ballot with the wrong, and I put wrong in air quotes, if they are a Republican and insisted on getting a Democratic ballot, or an unaffiliated and really wanted to vote Republican or something, that while the rest of their ballot would be rejected, that the nonpartisan school board, which they should be eligible to vote for, would still be counted. And again, that has passed both bodies. I'm happy to take any questions.
Yeah, Delegate Hornberger.
This is a great bill, and I support it. And my question is probably more for council. If there was, and I just thought about this, if there was a situation where the nonpartisan municipal folks were combined on that ballot as we have enabled, would those additionally be counted if someone were given the wrong ballot?
It's an interesting question. I don't think I haven't thought of that. I don't know if anyone else.
These are the things that keep me up at night. Because they're nonpartisan. So we'll look into that, but a great bill, and thank you for bringing it.
Okay, I was going to do my show and tell, but I believe that Delegate Roberson did that one. Okay.
Jared, do you want to come up?
Jared, you want to speak to that?
If you have a response. You can repeat the question,
Sure.
Delegate
So
Hornberger?
the question is, we want to count these, what I'll call school board votes, which are unaffiliated. Anyone, even a unaffiliated voter can come in and vote for school board in the primary. Okay, so in the scenario where a municipal government has agreed to combine their ballot on the state ballot, would those votes be counted? Because those are inherently nonpartisan as well.
I will start with that, which is not all of our municipal elections are nonpartisan.
Correct.
As you indicated, most of our 157 or 161 with our new taxing districts. But I know that Frederick, Annapolis, I think Bowie, there are, I think, 5 or 6 that are partisan. So nonpartisan, the answer is an obvious yes. For partisan, I would assume it would also.
They maybe would not appear on the primary ballot. Is there a situation where they could, and if so, would they be counted?
So if, I guess, Jared Damaris, State Administrator of Elections for the record here. Well, if you pass Delegate Wims and Senator Kagan's bill about the municipal elections, one of the caveats is that they would have to follow all our voting rules on that bill as well. So if they appear on our ballot, if it's a nonpartisan election, in this scenario here, with this, they would have to be counted along
Right,
with those
that's what I would think. I just wanted to confirm
Yes.
it. Thank you. Good bill. Thank you.
Okay, any other questions on this one? Thank you, Jared. That concludes the hearing on Senate Bill 543. Senator Kagan.
Thank you, Madam Chair. Colleagues, this is one of the two that are not identical, so I'm going to take an extra moment to describe the differences. First is Senate Bill 534, election judges, and Delegate Dana Jones was the cross-file, and we are in two different postures. This started off as doing two things. One is it says that if you sign up to be an election judge, and you go through the training, but then you don't show up during early voting or on election day, we're not going to pay you. So this is fiscally conservative, and it's about keeping your commitments, because then what we had was a bunch of counties, bunch of precincts that didn't have enough judges, and they thought they had filled all the slots, but then a bunch of people didn't show, and they were still paying them. So that's the part that both bodies have passed that we do want to stay in the bill. The part that Delegate Jones and I had in the original bill would have allowed students to choose to get both SSL, student service learning hours, and pay. And unfortunately, the Senate didn't love that. They really wanted it to be either or. And so this bill is not for and. It is just you still have to pick. So there are students who would prefer the dollars, there are students who would prefer the service learning hours, but unfortunately, with this bill anyway, they would have to choose. And so we hope that the House would conform to the Senate, because that's the way that, unfortunately, my colleagues wanted to pass the bill.
Okay, any questions from the committee? Okay, seeing none, that concludes the hearing.
Oh, and I should say, I'm sorry, Delegate Jones is okay with that. She's disappointed, but she can live with that. So just want to mention that.
Okay, that concludes the hearing on Senate Bill 534, and your last bill, Senate Bill 615.
Okay, so first off, let me just give a shout out to wonderful Delegate Feldmark, who has been the partner on this and the cross-file. This is a really important bill that I'm hoping will move this year. I can say that I've been working on it for several years, and this is different than the version you had last year. I want to thank the Vice Chair, the national experts, and others who have helped me to modify and update this bill. So I think we all are likely to be willing to admit that when a hearing is long and boring, that we kind of check out. And we kind of check our texts, or we scroll, or we check Facebook. No, Delegate Wells never does, but some of us do. The same thing happens when people are voting. When we give them jargon and legalese and doublespeak, they don't know what they're being asked. And so what do? They choose not to vote. In our most recent election, more than 400,000 voters who cast a ballot for governor chose not to vote in at least one of the ballot measures. They just were confused and they didn't want to do it wrong. So I want to show you a map here that I suspect that Delegate Feldmark might have shown you whenever that hearing was. And it shows that all over the country, there are 23 states, red, blue, and purple states, that have passed simplified ballot language. They did it really differently. And I can tell you, we went through, and I'm sure this is in your laptops, we went through every state's laws. We worked with NCSL, National Conference of State Legislatures, and they sent testimony to you all, as did the Center for Civic Design, a national expert, Whitney Quisenberry, who was kind enough to testify on the Senate side. And we went through laws that began as early as 1954 and as recently as last year. And we cherry-picked. There were some that limited the number of words and said you can't use more than 25 or 50 words. There's some that just were too vague or did the grade level language, which is what we did last year. It has to be as simple as 6th grade language or 8th grade language. We got rid of all that. And so what the current bill does is it just requires, and I want to also thank Chair Demarinis for his coaching on this, it requires plain English, no doublespeak, no passive language, no jargon. It sets up a process by which the language, the proposed language, is brought to the Secretary of State. It's brought to if it's a local bill, it goes to the state's attorneys. They evaluate it and see if it makes sense. It is then published publicly so that people have the chance to read it. Advocates and voters can say, nope, I still find this confusing. There's enough time for a lawsuit if that's needed, but we don't think that's going to happen. We think that this process is going to lay it out really well, and all of that will be completed in plenty of time to send the ballots abroad to our courageous troops. So there is, in addition to the Senate version of the bill, the Department of Information Technology just sent a suggestion that we like that just suggests that we also include, in addition to the Federal Plain Language Act and use the federal language, that we also consult with the new Maryland Plain Language requirements. I do want to also thank the governor and the Department of Information Technology. The governor last July came out with an executive order. We're hearing a lot about executive orders. There are fewer in Maryland, but Governor Moore did do an executive order last July about plain language, and this bill is totally in keeping with the requirement for plain language. And so I am happy to take whatever questions, but I'm really hopeful, and this is the year. Sometimes election bills, we think we should just pass them in election years. This one, we really have to pass this year if it can be in effect for any ballot measures that we have on the ballot for next year. The last thing I want to say is Delegate Wilkins and I, Vice Chair Wilkins and I, had conversation about what if the General Assembly passes legislation that we want to put on the ballot. It is already in current law that will go as indicated on the ballot, and so this actually doesn't apply to that. We thought that it did, and we originally drafted it with that, but that's actually covered. And so, again, I'm happy to take any questions, Madam Vice Chair.
Thank you, Senator. Any questions on this bill? All right, seeing none, that ends the hearing on Senate Bill 615. Senator, are there any more left that you have for us? Is that it?
Any more what?
Are there any more bills that you have for us? I'm just making sure we got through all 6.
I appreciate it.
Wonderful. Well, thank you, Senator. It's wonderful to see you.
You too. Thank you all.
And that concludes the hearings on all of your bills.
Thank you very much.
Next up, we will take Senator Watson. Senate Bill 369.
Good afternoon, Vice Chair. Good afternoon, colleagues. Senator Watts from the 23rd District. And to introduce this bill, my wonderful intern, because in the 23rd District, we train for leadership.
Hello, good afternoon, Chair Atterbury, Vice Chair Wilkins, and members of House Ways and Means Committee. My name is Shanoy Peard. I am a student intern for Senator Ron Watson, District 23 in Prince George's County. I'm here to ask for your support of SB 369, Public Libraries Automated External Defibrillator Program, also known as the Raimono A. Russell Act. SB 369 is a cross-file for HB 593, sponsored by Delegate Boifo, that has passed this committee and the entire House this session. SB 369 will adopt the House version that was already passed in the House. This legislation ensures that automated external defibrillators are present and accessible in public libraries across Maryland. With staff trained to use them in the event of a medical emergency. This bill was introduced in memory of Raimono A. Russell, a constituent of District 23 and a dedicated postal worker who tragically suffered cardiac arrest while on the route at the Crofton Library. At that critical moment, an AED was not available and may have contributed to his untimely passing. His story highlights an urgent gap in emergency preparedness within our public spaces. Immediate access to an AED can mean the difference between life and death. This legislation ensures that our libraries are prepared to save lives when seconds matters most. I respectfully urge the committee to issue a favorable report on SB 369. Thank you.
Excellent job. We see they are preparing our future very, very well in Senator Watson's office, so excellent job. Committee members, one question, Delegate Polakovich-Carr.
Thank you, Madam Chair. And Ms. Pierce, was that your name?
Peard.
Peard. Very nice job with your testimony. Senator Watson, thank you for bringing the bill. We were glad to move this out through my subcommittee. I just want to point out the bills are not in identical form. Did you want to comment on the different posture at all?
Yeah, we did receive some conversations. We just want to place the Senate version, merge the Senate version into the House version. Make it easy.
Thank you, Senator. Seeing no other questions, that ends the hearing on Senate Bill 369. Thanks so much.
Thank you, Vice Chair.
All right, I'll go a little bit out of order because I understand her committee is voting. Senator Hester will bring you up. Senate Bill 361.
Thank you very much, Madam Vice Chair, members of the committee. I am here to present on Senate Bill 0361, Election Law, Influence on Voters' Voting Decision by Use of Fraud. For the record, my name is Senator Katie Fry-Hester. This bill is identical to the cross-file by the wonderful Delegate Feldmark of HB 525, which this committee heard in February. I understand the committee had some discussions about ways to amend the bill. The bill did pass out of the Senate clean and unanimously. And so I'm happy to answer any questions, and also Jared Demarinis is here to answer any questions, but I would urge your favorable report. Thank you so much.
Any questions? All right, seeing none, that ends the hearing on Senate Bill 361. Thank you, Senator. Senator Quarterman, you are up next on behalf of the Washington County Senators.
Thank you, Madam Chair. Members of the committee, for the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. We have a local delegation bill here, Senate Bill 596. The bill does a number of things. First, it provides clarification to SSTAT on the tax exempt status to the Hagerstown Multi-Use Sports and Event Facility, which I believe many of you visited over the summer. We thank you for your site visit and hope to see everyone again here this summer. Additionally, it also tweaks a couple tax credit programs we have that are offered within Washington County for real property owned or leased by new or expanding businesses. And lastly, it requires a new business entity located in the county or existing business entity in the county to invest in capital improvements, as well as creating additional full-time positions. There's delegation letters in there, letter of support from the county commissioners. Bill passed unanimously. The cross-file did from this committee and on the House floor. So, I apologize, 136-1 on the House floor. Thank you. Appreciate a favorable report.
Wonderful. Thank you so much, Senator. I don't see any questions, so that will conclude the bill hearing on Senate Bill 596. Senator Guile, Senate Bill 923 and Senate Bill 770.
Thank you very much, Madam Vice Chair. Was there a particular order you wanted me to do these in? I have two.
If we can knock out Senate Bill 923 first, sure, since that's sponsor only, and then we'll move to the next one.
Sounds good. Thank you very much, Madam Vice Chair. Members of the committee, for the record, Senator Don Guile, here to present Senate Bill 923. This bill would require local education agencies, or LEAs, to ensure that sports officials for boys and girls sports are paid at the same rate. This committee had already heard HB 1483, the cross-file that was sponsored by Delegate Dana Jones. It's my understanding that that hearing was held less than a week prior to crossover, so it may still be in your recent recollection, but
Just by way of some quick background, during the interim, our constituents, Doug Silber and Jen Murphy, brought an issue to our attention, specifically existing pay equity laws. That despite existing pay equity laws, high school sports officials for girls' sports were being paid less for performing the same work as officials for boys' sports. And while current law aims to prevent pay disparities based on gender within both girls and boys' sports, they fall short in addressing pay inequities across boys and girls' sports, regardless of the official's gender. Senate Bill 923 aims to promote pay equity in high school sports officiating by implementing the following requirements: equal pay standards, simultaneous solicitations, inclusive bidding options, uniform submission deadlines, collaborative bidding flexibility. These measures aim to close loopholes in existing pay equity laws and ensure fair compensation practices across high school athletics. Per the fiscal note, implementing this bill would not require additional state resources, and I would request a favorable report on Senate Bill 923 as well as the House Bill 1483. Thank you, Madam Vice Chair.
Thank you so much. Seeing no questions from the committee, that ends the hearing on Senate Bill 923. Let's go to Senate Bill 770.
Thank you very much, Madam Vice Chair. Again, for the record, Senator Don Guile, District 33, here to present Senate Bill 770. As amended by the Senate, Senate Bill 770 would do two things. It would require each local school system to provide crisis support and assistance to a public school when a teacher or other school employee is removed from the classroom or school due to alleged criminal activity or for student safety. It would also require MSDE to convene a work group to examine the impact on public schools of adding history of boundary violating behavior to the school hiring process and examine the impact on youth serving organizations in the state of adding requirements for personnel hiring. Per the fiscal note at Senate Bill 770, this is a third reader fiscal note. The bill would not directly affect state government operations or finances. Senate Bill 770 is the cross-filed HB 1105 that was sponsored by the good delegate Edith Patterson. This committee heard HB 1105 on February 24th. As members can see in the bill file, various stakeholders have submitted amendment requests in its current form. Our staff just met with them just yesterday. We're in the process of actively considering and discussing some of those requests, and look forward to continuing those discussions. Also leave it to the good work of this committee if it decides to move forward the bill to consider some of those amendments as well. And for these reasons, I respectfully request a favorable report on Senate Bill 770 and HB 1105. Thank you, Madam Vice Chair.
Thank you, Senator, and I understand you may have some folks here in support of this one.
There's some folks that are favorable with amendments, yes.
Okay, so why don't we bring in, I know that we have a few virtual individuals.
Okay.
Why don't we start with Marla Navarro, and you can begin. You can unmute and begin. Maria, I'm sorry.
That's okay, no problem. Thank you, Chair Atterbury, Vice Chair Wilkins, members of Ways and Means. My name is Maria Navarro. I'm the Superintendent of Charles County Public Schools. I want to reiterate our support for the goals of this bill, which are first to make sure crisis support teams, a support team is deployed when it's actually needed. And second, to ensure students, families, and caregivers are supported, informed, and connected to the right resources after something traumatic happens. That said, we believe these goals are best achieved through updates to the Maryland Safe to Learn Act, as you'll see reflected in the joint testimony from MABE, PZAM, and MSEA. The Safe to Learn Act is already where Maryland law requires school emergency plans and requires those plans to be updated regularly. When passed in 2018, the law focused on physical safety and crisis support, but also included mental health and wraparound supports. As SB 770 rightfully reflects, not all crises are violent or physical. Responding to a crisis means addressing emotional safety and trust too, and the Safe to Learn Act framework can and could more explicitly cover that. That's why we propose amending the law to define crisis more broadly, anything that significantly impacts student physical or emotional safety, and to make communication plans an explicit part of those emergency plans. One last point, emergency plans, including communication protocols, are not foilable and not detailed in statute, and that's by design. It's first about safety, but from a communication standpoint, it's also about flexibility. There are different crises, medical emergencies, threats, or even different staff removal scenarios, and these all require different messages, tones, resources, and messengers. Over-specifying communication steps can backfire. Families absolutely deserve to be informed and supported, but when you specify plans, they might expect legal or medical advice or certain guidance that isn't appropriate in that instance. Thank you for the ability to provide some feedback today.
Thank you so much. Next up, Sean Bolson.
Good afternoon. I'll build on what Dr. Navarro has shared. Sean Bolson, Superintendent of Harford County Public Schools, also representing PZAM. And so, as Dr. Navarro indicated, we absolutely support the intent and purpose of this bill, but the superintendents really believe that there need to be some adjustments, and there certainly needs to be some nuance with regard to how we confront various crises. And so I'm not going to get into much storytelling there because we have one more speaker who I think can add some more context to this. So really, I would like to kind of jump to the closure, which is we've recommended specific amendments. And so rather than introducing this as a new mandate, a new specific law through SB 700, we recommend expanding the Maryland Safe to Learn Act, just so it includes a broader definition of crisis. And we're also able to update the communication protocols. So we would expand the school emergency plan, the definition to encompass events that overwhelm normal coping mechanisms, addressing both physical and emotional threats. So going through those specific amendments, we would ask you to attend to the amendments that we've submitted. But I think I'll stop there because there's enough to share. Again, we support the spirit of this. There's certainly a great commitment to addressing particularly our students' needs in crisis situations. But we would like to engage further in how to make this nuanced so that we're not providing crisis response in places where it could actually do more harm.
Okay, thank you. Mr. Henning, please, for 2 minutes.
Thank you.
Hennigan. Sorry, I pronounced it wrong.
Thank you, Madam Chair and Committee. Bernard Hennigan, I'm the Assistant Superintendent for Student Support Services in Harford County Public Schools. And I, along with Dr. Bolson and Dr. Navarro, also support this bill with amendments and want to just offer a bit of a different perspective. Currently in Harford County Public Schools, we have five crisis teams that respond to schools, and those consist of psychologists, counselors, social workers, and central office staff. They typically are responding for various traumas, but most notably for loss and grief support. We have had quite an uptick in Harford County over the last few years of student and staff deaths in our county. And in the typical year over the last 3 years, our grief response teams are responding to schools about 15 times a year. So this keeps them very busy. And it's pulling the staff from their schools where they otherwise might be attending IEP meetings, providing individual counseling to their own students, testing students, running groups. And so there is some concern that there's no standardized crisis response. Each situation dictates the different needs. And most times students, we have found, typically want to talk to the staff in their building that they're familiar with and comfortable with, not someone who's coming from another school that they don't know. The other piece of this bill that concerns me is there's a general reference to any teacher being put on leave regardless of the reason. And not every situation that results in a teacher being put on leave will have an impact on students. In addition, the need for crisis response is so nuanced, and in many cases, students are not even in need or open to services being provided. And furthermore, the staff being asked to provide the crisis response in these cases will not have the details of the case, and therefore will not be able to accurately provide the appropriate services or resources given the lack of information they have about the situation. So these are human resources matters that our staff won't have the information of. And if this bill would ever be enacted, it needs to be very specific in the types of situations that would lead to these grief response or crisis response teams being deployed.
Let's have Mary Pat Fannin come up, and then we'll do questions, Senator Guile, if that's okay.
Thank you. Hi.
There was also a Sam Mathias. Okay. And I know you two are favorable with amendment, so.
Yes. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Mary Pat Fannin. I'm the Executive Director of the Public School Superintendents Association of Maryland. I want to thank the Senator for being very open to talking to us and working through some amendment ideas, and I just want to show our testimony has 3 prominent logos on the top, and we put it on each of the 4 pages of our testimony with MSEA and MABE and PZAM. So we're trying very much to work together and come up with some solutions. And you heard from my superintendents and our Director of Student Services. The bill does have 2 parts, and so as wearing our LEA hats, we are talking about and wrote amendments to the crisis response piece. There's also the work group part that I think MSDE has provided some language for that report and that work group, so we're not going to speak to that. But again, I think the superintendents have made a strong case that one crisis may be very different from another, and that the responses have to be very nuanced, especially when it comes to removing teachers from schools, which unfortunately we do a lot. And sometimes those are for very founded reasons, and sometimes they're for unfounded reasons, but there are very strict protocols and investigations that have to happen in each of those situations. And so we really have to be very careful about respecting the due process and the privacy, but definitely responding to what is happening on the ground with the students, staff, and the community. So thank you very much for your attention.
And thanks very much, Madam Chair, Vice Chair Wilkins, and members of the Ways and Means Committee. My name is Sam Mathias. I'm the Legal and Policy Services Director at MABE. And really, I think just to underscore, and also thank you, Senator Guile, and to your staff for working with us on this, but really just to underscore, I think, how aligned MSEA, PZAM, and MABE are on this. I think that Superintendent Navarro said literally everything I was planning to say, so I would just reiterate and support, that we truly do support the goals of this bill and believe it is best situated within the Maryland Safe to Learn Act. Thank you, and happy to answer any questions.
Okay, any questions? And I know I walked in the middle of that, but Senator Guile, is there anything you wanted to respond to that you heard today from any of these witnesses? Feel free.
Yeah, thank you, Madam Chair. I mean, I think just to give the committee a little bit of background of the origins of this bill, there was an incident in my district involving a teacher who was removed from the classroom, 50 counts of child sexual abuse, his trials in May. Of course, these are allegations, but there were some complaints raised by some of the parents that there was a lack of crisis support that was provided, whether it be communication, whether it be counseling, whether it be other information. I think that was partly due to some defensiveness and concern about litigation. So I think, and in speaking with some of my colleagues, it wasn't just merely this incident, but in speaking with some of my colleagues, I also learned that there were some similar frustrations in other schools and other areas. And so that was kind of what brought about this bill. And as I indicated earlier too, happy to continue working with the stakeholders on this, realizing that we are getting very close to the end. So thank you, Madam Chair. I appreciate that opportunity.
Okay, questions? Delegate Ebersol.
Thank you very much, Madam Chair. Thank you for bringing this bill. You know, I've taught for a long time, and there were some teachers who exhibited some very bad behavior over the years, and I'm glad that we're paying attention. I have a couple of just kind of technical questions. Sure. We start off with saying if a teacher's removed because of alleged behavior, so your idea would be they would be removed first. In other words, any alleged criminal behavior wouldn't trigger this. It would be something that the school system thought they should remove them from the classroom for. For example, if they got pulled over the weekend and that upset somebody, that wouldn't trigger it unless the school system thought, because they were going 180 miles an hour, that maybe they should be considered. So that's the order of things, right? First, there's some sort of alleged behavior that caused the school system to remove them from the classroom. That would trigger the crisis team.
I would agree with that assessment. I think the severity would have to rise to the level of the necessity of removing the teacher from the classroom. The original intent, of course, was thought of as some sort of, the need or the reasoning for the removal of the teacher related to some sort of interaction abuse or anything like that type of allegations. It was a little bit more broadened, but correct, it would have to be removal from the classrooms. Thank you.
And in the uncodified section, and I'm going to tell you where, but I'll read it so you don't have to go looking around.
Okay.
You describe
you.
boundary violating behavior. There's a couple of really good ones at the beginning, but the third one starts off with it's considered a behavior that is otherwise inappropriate. Okay, so I think that's a broad definition. After that, you have some examples, but they are only examples. Inappropriate behavior could be pretty broad in that case. I mean, there are other inappropriate behaviors to be sure.
Yeah.
And then in the next section, you go on to say that the commission or the group should go further to define that boundary behavior. I wonder why maybe we wouldn't have the definition there to start with if they were going to establish it. Just a thought.
Yeah. That's I'm sorry, were you done?
No, I was.
Oh, thank you. I appreciate the question, Delegate. Some of the concerns originally with the bill as drafted were exactly what you pointed to, that there may be some open to interpretation as far as what inappropriate means. And I think part of what the intent was at the outset was sometimes there are behaviors, I would say, that are similar to like grooming type of behaviors that may lead ultimately to child sexual abuse that are hard to define. And I know that in the incident that happened in my district, that's exactly what is alleged to have occurred. And I think that's oftentimes what unfortunately does occur in similar situations. That being said, given that, it may end up not allowing somebody to teach, or to work in a school setting on the basis of having some, broadly or vaguely defined inappropriate behavior. That's why we ended up modifying the bill to be more of a work group to look into what this means and to try and to, I guess, pin it down a little bit more if there are some previous allegations of this type of behavior, but thank you, I appreciate that feedback.
Thanks. And just one more, the fiscal note's a little vague on what the cost, and maybe this comes to one of the people who's come to talk to us, the cost of, because there's a couple things specifically in the bill that you have to have legal counsel, you have to have a trauma-informed counselor available. Some school systems are probably ramped up and ready to go this, some of the smaller ones might not be. Without something with the fiscal note, do we have any idea what having teams like this ready to go, is there a large fiscal impact or not? Maybe some of the other folks want to answer that, or maybe you can. If you should go first.
I'm happy to chime in. Thank you, Delegate. So I think that, one, hopefully these situations are really rare, right? One would really hope that this wouldn't, it does unfortunately happen with more frequent.
I saw several in my years of teaching.
I know, well, that's the sad, truly sad part about it is, but one would hope that it would be as infrequent enough that this is not some sort of like standing crisis team that's available to jump in at any moment, but people that are trained, that are already working in different, so people this can be done with existing resources within the school. So that's what that was anticipated to. I feel I can, happy to, if anybody else from the panel wanted to offer their opinion, assuming Madam Chair is okay with that. But that's what was contemplated, I guess, from the committee's work, that it could be done with existing resources.
Okay, thanks.
Thank you, Delegate.
And Dr. Navarro, it's good to see you. We talk sometimes, and nice to see you today.
Okay, are there any other questions from the committee? Okay, seeing none, thank you very much.
Thank you very much, Madam Chair, Madam Vice Chair.
Thank you to everyone who testified, and that concludes the hearing on Senate Bill 770. I'm going to do the two with no witnesses before Senator Sidnor. Senator McCray. Senate Bill 550.
Thank you. Thank you, Madam Chair, Madam Vice Chair, members of the committee. It is always good to be in Ways and Means. For the record, Corey McCray, Senator for the 45th Legislative District. I'm here in reference to Senate Bill 550. And before I start, Madam Chair, I'd just like to thank my cross-file, which is also my district delegate, Delegate Young, for cross-filing the bill. And Madam Chair, Senate Bill 550 is a little bit personal for me. See, I'm born and raised in the city of Baltimore, and there's a block in my neighborhood, the 600 block of North Castle Street. The 600 block of North Castle Street, we gave you all pictures so you would have a level of a visual, but that has been vacant since I graduated from high school. And one of the things is sometimes you fall short in utilizing your power to represent individuals. So I'll say that I've been elected for going on my 11th session at this moment. And unfortunately, myself, the folks that preceded me, never challenged the organization that had owned those respective properties on that block. Well, there did come a time where I did question and make the question to the respective organization. And I asked them the question, I said, for the last 25 years, on the 600 block of Castle Street, where people still live, you all have extracted generational wealth from them because those properties have decreased in value simply because the properties next to them or adjacent to them are vacant. And when I brought it to their attention, because I had to leverage another position that they were doing, I said, I don't want to have this conversation until we have a conversation about the 600 block of Castle Street. Let me be clear, 600 block of Castle Street is going in the right direction. It's actually an RFP to turn all of those parcels, it's 20-plus parcels, into home ownership. But we shouldn't have to leverage power like that in order to do things such as that. So this bill, Senate Bill 550, is just guardrails for situations like this because they happen all across the city. I'm not sure if you all know, but for the last 10 years, we've been losing population for a variation of reasons, and I would submit that this is one of the reasons that we are losing population. So this is a nonprofit that owns this. So this is one of our anchor institutions that own those multiple parcels. And I just say that I don't care if it's for-profit or not-for-profit, the behavior that we exhibit have to be neighborly and making sure that we're taking in consideration those folks that live on those respective blocks from that standpoint. This bill, Senate Bill 550, just says, and it's been amended, so it's been amended the way we can work with the stakeholders that may have had some level of opposition, but it says that if a parcel is vacant for more than 5 years, then that respective jurisdiction, which is the city of Baltimore, will be able to set a special tax rate for them up to 10 times from that standpoint. They acknowledged that their behavior was not worthy of those folks that were living on that block. And we acknowledge that as leaders, we should not ever allow something like this, but we shouldn't allow it to happen for 25+ years from that standpoint. So this guardrail bill has passed out of the Senate, 47-0. It's currently in the House from this standpoint. I did get a number of questions, Madam Chair, from the committee analysts where Delegate Wells and Delegate Young was on it, and I would like to answer some of the questions that was presented to me. And they asked, how would the city know the properties owned by the nonprofits are vacant and haven't received significant improvements for the last consecutive respective 5 years? And I say that SDAD had sent me a list because I thought about that one block, but then I said, well, how many other blocks is this happening in? And SDAD sent me a list of all of the blocks. And what happens is they're actually taxed, but they're taxed very nominally. So they were paying about $100 a parcel, which is nothing. It's drinking money for, so we can find this under the couch. And that's no incentive to move or change behavior from that standpoint. But SDAT is the way you will find something like that, and I responded with that. The bill doesn't define vacant or significant improvement. And what happens is this is an enabling legislation. The mayor supports this bill, so they've actually submitted testimony saying, yes, we agree that this should not happen along with the organization that was conducting the behavior. But let that local jurisdiction set what they define as vacant and hasn't had significant improvement. It said, why are only nonprofits included in the proposed class and why not include for-profits? I say that the House does phenomenal work. The House passed a bill that was called House Bill 2, I want to say in 2024, led by the leadership of Delegate Boyce. And what happens is those for-profits are already moving in that direction, but we have this subtier or this subset of folks that are not moving in the right direction. And then it said, as drafted, the bill would apply to small, medium nonprofits as well as large nonprofits like Johns Hopkins. Is it the intent to impose the high tax on small, medium-sized nonprofits? I say to you all, I don't care if you're small, medium, or large, you should not treat neighborhoods like this from that standpoint. So that was my response to this. After I got this subset of questions, I then got another series of questions. And I just reiterate, vacant will be defined on a local level. We talked about House Bill 2 in 2024. It didn't apply to nonprofits, it applied to for-profits. The nominal tax, I did already speak to, like how much were they paying in property taxes because SDAT had sent that respective information. Significant improvement, we talked about that. There was opposition. The only people that was in opposition, that was worked out. It was Hopkins and it was the Catholic Conference. But like I said, we moved from 3 to 5, but I say that they shouldn't even be doing that at 3. So 3, you shouldn't be conforming to that behavior. But at the end of the day, this is about finding a middle. And we did find a middle from that standpoint. And we moved it up to 5 and made it clear that we're not talking about properties where there's a coffee shop or things of that nature. We love that because that's producing economic activity. We're talking specifically about vacant and properties that they have not done any, or land that they have not done any level of improvement from that standpoint. And then I just wanted to read like the last piece that I exchanged with one of the folks that was in opposition. And I said, what's the logic in allowing properties to sit vacant for 5 years or more, and how does this uplift our community? SB 550 is simply about accountability and ensuring the long-term vacancies, regardless of ownership, aren't stalling growth and opportunity in our neighborhoods. Our communities deserve spaces that serve, not structures that sit empty. This bill ensures that while also giving organizations time to repurpose and reactivate their properties, that we're also holding them accountable from that standpoint. I got visuals where I can show you these properties were vacant in 2007. I got visuals I can show you it was vacant in 2018. I got visuals that I can show you it was vacant in 2024. I just say, please pass Senate Bill 550 so that we can eradicate these types of challenges within not just my district, but my city, and we can support growth in our respective jurisdiction because we're on the right direction, but we have to alleviate some of these pressures that we have.
Okay, any questions for Senator McCray? Okay, thank you very much.
Thank you, Madam Chair.
That concludes the hearing on Senate Bill 550. Senator King, Senate Bill 516.
Thank you, Madam Chair. Nice to see you. Okay, Madam Chairman and members of the committee, Senate Bill 516 is an exact cross-file of Delegate Polakovich-Carr's House Bill 389. It's a great bill, which was passed by this committee and the full House. This enabling legislation is just one more tool to help increase child care openings in our state, and I respectfully ask for a favorable report on Senate Bill 516.
Okay, are there any questions? Okay, thank you very much.
Thank you.
Good to see you too. That concludes the hearing on Senate Bill 516, and to wrap it up, Senator Sidnor, and you have a panel that is virtual, so let's check and see if they're all here, and we can just bring them in. But if you want to get started while we're bringing them in, that's totally fine.
Oh, great, will do. Good afternoon, Chair Atterbury and members of Ways and Means. In 2021, a Baltimore County Redistricting Commission was formed by our county council in Baltimore County and proposed a redistricting plan that would maintain a white majority in 6 of 7 council districts by packing a supermajority of black voters, and I'm talking 70+%, into a single majority black district, a tactic that the U.S. Supreme Court has counseled against. Advocacy organizations, my colleagues, and I lobbied the county council to amend the map to better reflect the demographics of the county. Instead of doing that, the council amended the map, creating an even more precarious council districts and maps. The council's response led me and a few other Baltimore County citizens to join the ACLU, League of Women Voters of Baltimore County, the Baltimore County branch of the NAACP, Common Cause Maryland, in filing a federal lawsuit challenging the racially discriminatory and unlawful redistricting plan approved by the Baltimore County Council. Ultimately, the federal court issued an injunction overturning Baltimore County's racially discriminatory redistricting map and requiring the county to reconfigure it in compliance with the Voting Rights Act. In 2022, the town of Federalsburg, located in Caroline County, was sued to end a discriminatory at-large election system that has kept governance exclusively white for 2 centuries in a community that is now nearly half black. However, in June of 2023, through charter amendments, legislation, and a federal lawsuit, Federalsburg's at-large election system was changed to a 2-district system to ensure more representation of Federalsburg's black residents. For the first time in its 200-year history, the town, whose population is about 43% black, elected its first black leaders. In 2023, several civil rights groups filed suit against Wacomico County for violations of the Federal Voting Rights Act, challenging the at-large component of the election system for Wacomico County Council and its Board of Education. Although Wacomico County is comprised of around 30% black people and 40% non-white people in total, 6 representatives are white and only 1 is black. It has been alleged that the county employs a partial at-large structure which perpetuates a legacy of discrimination by the county by limiting black voters' opportunities to 1 majority black district among the 7 seats available by the council and the Board of Education members. Now, it's my understanding that this case has recently been settled in principle by the parties and simply needs the court's approval. And today, my county again stands at the precipice of another possible lawsuit stemming from the county council's creation of a new 9-member council map, which was passed in conjunction with legislation to increase the council's size from 7 to 9 members. This map was passed without any meaningful public input and prior to a convening of a redistricting commission, which recently has begun to meet in Baltimore County. So why the need for the legislation? While the Federal Voting Rights Act gives the U.S. Attorney General the ability to sue any government which violates the Federal Voting Rights Act, the reality is that office does not have the capacity to get involved in every violation that occurs across the United States. In the cases I described, Maryland voters' rights were not championed by the U.S. Attorney General, nor even our state's Attorney General. They were championed by nonprofit organizations that wanted to see the government do the right thing. However, it is extremely important that citizens not only have to rely on hiring private attorneys to do what can be done by our state's Attorney General. So as such, Senate Bill 342 grants authority to the Maryland Attorney General, as well as any other person, to enforce the Maryland Voting Rights Act of 2025, and it allows plaintiffs to seek injunctive relief, damages, or other relief if a county or municipality or municipal corporation violates the bill. Senate Bill 342 also prohibits Maryland counties and municipalities from imposing or applying methods for electing its representatives in a manner that impairs a protected class member from electing a candidate of that member's choice or impairs that protected class members' ability to influence the outcome of an election as a result of the dilution or the abridgment of that protected class member's voting rights. The legislation provides the intent to discriminate is not required to establish a violation, and it provides 5 probative factors which may be used to establish whether a violation occurred. Those factors can be found under sections 8-904A. To prove that a violation of the Maryland Voting Rights Act of 2025, a plaintiff would have to establish 1, that a county or municipal election exhibits polarized voting, or 2, that the method of the election dilutes or abridges the voting strength of a protected class member's ability to influence the outcome of an election. Finally, under Senate Bill 342, when making a determination whether polarized voting occurred, the court must consider the methods for estimating group voting behavior as approved in federal case law, to enforce the Federal Voting Rights Act of '65, whether elections of the governing body of the county or municipality, ballot question elections, elections where at least 1 candidate is a member of a protected class, as well as other electoral choices that affect the rights of privileges of our protected class members. So, for the aforementioned reasons, I ask that this committee please provide a favorable committee report on Senate Bill 342 and on the panel, you'll hear some folk who are much more expert than I. So thank you.
Thank you. And first, we'll hear from Michael Pernick, please, for 2 minutes.
Thank you very much, Chair Atterbury, Vice Chair Wilkins, committee members. My name is Michael Pernick. I'm a political participation counsel with the Legal Defense Fund, or LDF. I appreciate the opportunity to testify today in support of SB 342, which is a key piece of the Maryland Voting Rights Act legislative package. Since LDF's founding by Maryland native Thurgood Marshall, LDF has worked to empower Black voters across the country. And in recent years, state voting rights acts with provisions like SB 342 have been one of LDF's top priorities. Now, Maryland has made significant progress in building a more inclusive democracy in recent years. But given rising threats at the federal level, ongoing challenges in Maryland, we urge you to pass SB 342, which will enshrine baseline protections against racial vote dilution, which is a pervasive and insidious form of racial discrimination in voting. Now, to be clear, as Senator Sidnor explained, similar protections against racial vote dilution currently exist at the federal level under Section 2 of the Federal Voting Rights Act. But the federal VRA is under threat. In recent years, key provisions have been invalidated or weakened, and we know that litigation under Section 2 of the federal VRA is costly, complex, and time-consuming. As a result, violations often go unenforced or cost taxpayers and parties inordinate sums of money. SB 342 takes the same types of protections that have long existed at the federal level and enshrines them into state law. It provides a more streamlined legal test to make litigation more predictable, less time-intensive, and less costly, and it benefits voters who seek to vindicate their rights, as well as local governments seeking to comply with the law. We know this is an extremely popular bill based on polling. More than 3/4 of Maryland voters strongly support these provisions, and we at LDF believe that enacting SB 342, along with the other parts of the Maryland Voting Rights Act package, represent the single most important action the legislature can take right now to protect our democracy. If helpful to the committee, I'd be happy to discuss the provisions in more detail or take any questions. Thanks again for the opportunity to testify.
Okay, thank you. Morgan Drayton for 2 minutes, please.
Good afternoon, Chair Atterbury and members of the committee. My name is Morgan Drayton, Policy and Engagement Manager with Common Cause Maryland, here in support of SB 342, which would enact some of the strongest possible protections against racial vote dilution at the state level. The protections provided in this bill are essential to ensuring that all Marylanders, particularly those from historically disenfranchised communities, have an equal opportunity to elect representatives of their choice. Although Maryland law features important pro-voter policies, it contains no protection against racial vote dilution. Recent challenges to racially diluted voting systems in Federalsburg, Wicomico County, and Baltimore County underscore the crucial need for these types of protections. In 2022, a group of Baltimore County voters joined with Common Cause Maryland, the Baltimore County NAACP, and other partners to file a federal lawsuit to challenge racially discriminatory and unlawful redistricting plan that was approved by the County Council the previous year. According to census data, about 30% of Baltimore County residents are Black and nearly half are people of color, reflecting the growing diversity within the county. Despite this, 5 out of 7 districts in the plan the council originally approved were majority white, and a sixth had a 49.41% white plurality in its voting age population, meaning that an excessive number of Black voters were packed into the single majority Black district within the county. We heard that after hearing the evidence, a Baltimore County judge filed a preliminary injunction requiring the map to be redrawn to ensure more proportional representation for the county's residents. But a prohibition against vote dilution will help prevent issues like this from becoming law in the first place, saving both voters and local governments time and money spent on costly litigation. And yesterday we saw President Trump sign a far-reaching executive order seeking to overhaul how our elections are run. This order stands to disenfranchise thousands of Maryland voters. So we see that now is the time to take action to protect voting rights at the state level. So for these reasons, we would respectfully urge a favorable report on SB 342. Thank you.
Thank you. For 2 minutes, Dana Vickers-Shelley, please. You're on mute. Try now. Looks like you're off mute.
Thank you, Madam Chair and committee members. I'm Dana Vickers-Shelley, Executive Director of the ACLU of Maryland
Maryland, speaking in support of SB 342 to end discriminatory voter dilution and protect Marylanders from having their votes weakened or discounted based on race or the color of their skin. In addition to being at the ACLU, I'm also a Baltimore County voter where we do not have the opportunity to be fully represented because of how voting is done and the options. Racial vote dilution occurs when an election system or other policy denies voters of color an equal opportunity to elect candidates they support. This means that voters of color can cast ballots, but that their votes do not have equal power or weight compared to white voters. That is unacceptable, especially in a democracy. Sadly, as you've heard, litigation under federal VRA is becoming much less effective in the courts. And as a result, the federal VRA is at significant risk of being further weakened or destroyed entirely. Knowing this, we must pass state protections to ensure continuing safeguards for all Marylanders. Maryland has a troubling history of racial suppression, and laws that have the purpose or effect of discriminating against Black voters and other voters of color remain far too prevalent. In addition to the areas presented by Senator Sidnor, other Maryland jurisdictions, polling places have insufficient resources or fail to provide adequate assistance at the polls. These voting practices persist because the federal VRA cannot fully combat them. As of 2024, 54% of Maryland municipalities have substantial Black and BIPOC populations, and 23 of those municipalities have all-white governments, indicating a high risk that voters of color in those communities have not been able to elect candidates of their choice. I myself was a plaintiff through protracted legislation that ended with the federal judge advising the Baltimore County plan likely violated the federal VRA. Thank you so much for hearing our thoughts. We hope for a favorable vote.
Okay, thank you. And Lada Knott, please, for 2 minutes.
Thank you, Madam Chair and committee members. My name is Letha Knott. I'm the Director of Voting Rights Policy at the Campaign Legal Center, a nonpartisan organization that defends and promotes voting rights. CLC litigates cases under the Federal Voting Rights Act and has supported efforts to pass state voting rights acts across the country. I'm testifying in support of SB 342, core piece of the Maryland Voting Rights Act. And there could not be a more important time to enact a state voting rights act. As my colleagues have said, federal voting rights protections have been weakened, and Congress has refused to fix the problem, and we now have a president openly hostile to minority voting rights. And although Maryland has laws protecting against racial discrimination in employment, in housing, in other areas of public life, there's currently no state law barring racial discrimination in local elections. And that's exactly what SB 342 would do. It would fill this critical gap and codify the rights of voters in Maryland and the Maryland Attorney General to challenge maps and methods of election that dilute the voting power of historically disfranchised communities. And making that right a part of state law ensures that Marylanders will always have the ability to enforce their own rights, regardless of what happens at the federal level. This bill also provides guidance to courts on how exactly plaintiffs can prove that their votes have been diluted. And it's important to note that providing clarity in this area will not lead to a slew of litigation. In fact, in states that have enacted similar protections, and since 2018, that's 6 states that have adopted state VRAs, only 7 lawsuits have been filed total. This bill also empowers state courts to consider a wide range of remedies to fix the problems and choose the one that's best suited to help the impacted community, correcting an egregious flaw in the federal VRA that has led courts to give deference to the remedy proposed by the government that violated the community's voting rights in the first place. If passed, this bill will be a critical tool to protect voters from discrimination, and thank you for your time.
Okay, thank you. And we have questions, and we'll start with the Vice Chair.
Thank you so much, Madam Chair, and thank you, Senator, for bringing this bill and your leadership on this really important issue. I know that the advocates for this bill have been working a number of years now around Voting Rights Act legislation to implement here in Maryland. I'm really just trying to unpack the bill a bit, so please just bear with me a bit here. It sounds like the current posture of this bill is that we're focused in on the counties and the cities, specifically how the districts might be drawn in a way that might prevent reflective representation in terms of protected classes. Is that an accurate summary?
The operative section is on page 2, lines 24 through 30. So to your point, yes, it's something to ensure that certain protected class members are, their rights aren't impaired. That's what the bill is about. And the sole reason that you were dealing with counties and municipalities is because if the Attorney General is bringing an action, the Attorney General is generally the attorney for the state. So these kind of matters really shouldn't be coming forth because the Attorney General would have caught or should have caught these things prior to them having to go to court. So the issue has been with our more local governments.
Sure. Okay.
And if I may say, really in pulling testimony together, and I talked about Federalsburg, I talked about Wacomico County, and I talked about my experiences in Baltimore County. The fact of the matter is these cases don't happen all that often, but when they do happen, they can have a tremendously harmful effect to communities when it comes to representation and resources coming within those communities. I put the bill forth because I thought that it was unfair to put that burden on the citizens to have to go and find private counsel to bring these cases. And reflective of what happens at the federal level where you have the U.S. attorney bringing these cases, I thought it would make sense that our state attorney general would be able to bring forth the same types of cases.
Got it. Thank you so much, Senator. That's super helpful. To be super clear, just at 100,000-foot level, what this bill is seeking to address is that when counties or municipalities draw their districts, that there is an opportunity for the representation that is elected to look like and reflect the people of that district,
Yes.
whether it's race, gender, and other classes. That's the core foundation of it.
Yes.
My understanding of this bill is that it's not focused in on how to draw the districts, but this is about making sure we have that prohibition in law so that the Attorney General would have the opportunity to file suit. Is that the posture of the bill? It's not about how the districts are drawn, but it's kind of an after the fact Attorney General being able to draw suit. Is that?
Right. The Constitution already dictates how the district should be drawn. This is this is a tool that the Attorney General would have, and as well as any other person would have if the Constitution is not followed.
Got it. Thank you. The term polarized voting is defined in the bill, but I know that this discussion has talked a bit about vote dilution. Are we using those interchangeably, or perhaps some of the advocates can clarify for all of us what we mean when we say vote dilution versus the definition that we have here in the bill around polarized voting? Can we clarify?
The NAACP Legal Defense Fund, they've certainly been very critical in some of this language, so I would defer to Mr. Pernick if possible.
Thank you, Senator Sidnor. Chair, may I proceed?
Yes, go ahead.
Thank you very much. Yes, Delegate, to answer your question, the term racially polarized voting or polarized voting has a long and well-defined history in federal case law. That's long been seen as the crux, and I quote from federal case law and from the United States Supreme Court, the crux of a racial vote dilution violation. When we see voting patterns where a particular minority group generally supports one candidate or certain candidates, and the majority group votes as a block to deny minority voters an opportunity to elect candidates of their choice. Take a classic example in the redistricting context. Let's say there's a significant community that's predominantly comprised of Black voters that would be large enough to elect a candidate of their choice to one county legislative district. But that community in the redistricting process is cracked across 2 districts and paired with other communities that don't support the same candidates as Black voters. that community could be denied any representation in their local government as a result of that configuration. And it's a direct consequence of these polarized voting patterns. So that's why that's the crux of this inquiry and what courts have long recognized as the most important telltale sign of a circumstance where racial vote dilution can occur. It's the same thing in the Federalsburg case in an at-large election. If you have a community that's, let's say, 30 or 40% Black, that generally prefers certain candidates, but the majority votes as a bloc to deny that community any voice in their local government. Those are the sorts of scenarios that have long been addressed by the Federal Voting Rights Act and would be squarely the sort of scenario that could be resolved under the same protection that would be brought into Maryland law, just in a more efficient and streamlined fashion than we currently have under the federal VRA.
Okay, thank you so much. I appreciate your time and all the advocacy.
Okay, Delegate Hornberger.
Thank you, Madam Chair, and thank you for bringing this bill. I had some questions for this when the House bill was presented, and I believe Mr. Pennick was nice enough to answer some of the questions. So two lines of questioning here. The first line will deal with the supremacy clause and preemption. So let's say I'm a resident of Baltimore County and I independently think that the maps are askew, and I go and file with the federal courts in the case that you've outlined here. And then at the same time, one of the advocates, I think they stated they live in Baltimore County, they file with the state. So the state goes through its legal process and determines that the districts do, cracking or packing, whereas the federal government says, we feel that this is acceptable. Who wins? Who's the deciding factor?
Are you asking me or Mr. Pernick?
Yeah, you or any member of the panel there.
Would
Mr. Pernick, Mr. Pernick, can you answer that? Did you hear the question?
I did. Thank you, Delegate, for the question. So this would create a new independent obligation under state law to prohibit racial discrimination in voting in the form of racial vote dilution. So in the hypothetical scenario that you're describing, if a map is passed and it violates a state law, then it could be struck down under state law. If a map is passed and violates federal law, it could be struck down under federal law. It provides an independent basis to measure and evaluate violations. Now, practically speaking, there have only been a handful of state VRA claims filed. As my colleague Latanat from CLC explained a few minutes ago, in the 6 states that have passed state VRA since 2018, only 7 lawsuits have been filed. So these tools are used rarely, but when they are used, it's for extremely good and extremely important reasons. And we've seen in those cases that the plaintiffs often make the point in state court that the violations would amount to a violation of both the federal VRA and the state VRA. And the reason to bring the claim under the state VRA is because it's more efficient, more costly, it can move forward more quickly, and at a lower cost to all of the stakeholders and all of the parties involved. So we're not seeing that sort of conflict. There's never been an example that I've ever seen in all 7 of those cases of parallel state and federal cases coming out in different outcomes. This is really about providing those protections to protect against the attack on the Federal Voting Rights Act at the federal level, and to have streamlined, efficient tools that are available to all stakeholders in the process in Maryland.
Great, and that's what leads me to my second line of question that I've thought about in between when the House bill and your bill is brought forward here, is the question of sample size. So most of these federal cases, if not all of them, deal with congressional districts, indoors, statewide versus statewide. So when you have a sample size of roughly 750,000 people versus another congressional district, it's pretty easy to see that there's intent there, just because you have such a large sample size. I would make the argument that in a county, as you've described here with your anecdote, that's probably similar too. You could probably suss out, hey, look, there's intent here. We know what the outcome's gonna be. It's fairly provable. So what I want to do is I want to jump down to the municipal level, all right? I've got towns in my district that are 500, 700 population. And many of these elections, there might be a dozen, 50, 100 voters. Extremely small sample sizes. And in terms of candidates, many times they're uncontested. Maybe there'll be 4 people running for 3 positions. how do you effectively prove with a sample size that small that one, this has happened, and two, that there was, there may or not be intent, but the outcome is such that. And then secondly, and because of that sample size is so small, we struggle to get people to vote or to run. So, that you might say, hey, this should be a councilmatic district because of the population. Maybe it's even split, but we might have only 3 people running of one certain nationality versus a fourth. It gets very difficult when you get down to these very small sample sizes. So if you could kind of speak to that, how would a case be brought? How would that be adjudicated when we're struggling to get people to participate at both the voting level and the candidate level?
If you wouldn't mind me taking a crack at answering that.
Sure.
Well, so first of all, intent isn't really what we're looking at here. You can have local governments, municipalities that have perfectly very good intentions, but sometimes just the structures in place end up diluting people's voting power.
Sure.
And I think, sorry to touch on like the earlier question about what's the difference between racially polarized voting and vote dilution. Racially polarized voting is basically you have different racial groups prefer different candidates, and that tends to be true across the board. And so when the majority racial group votes as a block and the minority racial group votes as a block, the minority group's candidates tend to be defeated. But that is not the same thing as vote dilution. But the second part of the test that's actually in this bill is, okay, so you have a minority group that's not able to elect candidates of their choice. The second question is, okay, well, would there be a system where they could have more representatives that they prefer? Right. In a case where, for instance, the minority group is, I don't know, like 1% of the population, and you have, say, an at-large election, maybe there isn't a scenario where they would be able to elect more representatives their choice, in which case you can have racially polarized voting, but not vote dilution. And so that's sort of built into what you're asking about, like with a small sample size, like you can if you have data from election returns, you can like assess if there's racially polarized voting. But a key element of vote dilution is that there has to be a way that that community would be able to get more representation.
So it's a two-part test, in other words, and if there's not a large enough data size, then then you can't make a determination. I guess that's what you're saying.
To be fair, it's a two-part test. There is also a provision of the bill that says, in addition to having this data that establishes racially polarized voting, plaintiffs can also present more qualitative evidence of basically historical fact, like the history of discrimination and the effects that that has on the historically disenfranchised community, or barriers that candidates from the community and voters face to the ballot box to participation in the election. So there's data, but there's also another element of qualitative data, which is especially important if you have an election and it's just the discriminatory structure is such that minority candidates don't run for office because they think it would be futile.
Okay.
And just so that if you look at the bill, page 2, starting at line 31, that's the two-part test that she was referencing.
Yeah, I'm looking at that and update if that's going to. Okay, and then last question, if I have one more. Okay, so, and we've debated this, been in this committee for 11 years. So this has come up numerous times, and it tends to be problematic when you have at-large voting, right? So you have a huge district. For example, we have in Cecil County where you have 100,000 people. We do have districts, you have to be a resident of that district, but everyone votes at large. And this occurs throughout the state, right? We have multiple counties where there's at-large voting, even though there's councils, councilmatic districts. So if it is determined that one of those is inherently a violator of this two-part test that you set forward, does that automatically apply to the other districts that are following the same scheme?
No, just like the Federal Voting Rights Act, this is a case-by-case assessment. A jurisdiction could only be held liable if there is evidence in that jurisdiction that the structure is racially discriminatory and there's a remedy that would address that racial discrimination. And that goes to your previous question as well. Just to make clear, the federal VRA has not just been used to challenge at-large, or rather statewide elections. It has also been used hundreds and hundreds of times by courts successfully at the local level and at the hyper-local level. But just like the federal VRA, there has to be evidence that there's racial discrimination, that there's an alternative method or an alternative approach that can fix that discrimination for anything to be actionable.
Okay, thanks so much. I appreciate it.
Okay, Delegate Young.
Thank you, Madam Chair, and thank you, Senator Sidnor, for your leadership on this issue for quite some time. I looked up a tweet from October 2021, I think it was, where I tweeted about this, and you were the one person that liked the tweet.
It's true. I remember that photo.
Isn't that so? Right. And I want to quickly shout out Dana Baker-Shelley, who is my former boss at the ACLU, and who gave me the opportunity to speak at that press conference that you were talking about in Baltimore County. That was a wonderful day. So I want to just touch on vote dilution quickly, and then I want to touch on the analysis of the mandating a majority-minority district under the Voting Rights Act. And just want to make sure or get clarity on the record on whether you want that same analysis, because the bill has a little bit of a different analysis. We heard about vote cracking from the NAACP Legal Defense Fund, but I just want to make sure that we're also, when we're talking about vote dilution, we're also talking about vote packing, which I think is more appropriate for what happened in Baltimore County. Is that correct?
Correct.
All right, so just want to make sure that's on the record. And then, so to the second question, I'm going to just quickly read off the four-pronged test under the Voting Rights Act, Section 2, that we used in the Baltimore County situation. And I just want to get your feedback on, and maybe somebody from the panel, on how this might interplay with this bill on the state level. The four-part test is, and I think this might also speak to some of what you talked about, Delegate Hornberger. Number one, the minority group is sufficiently large and geographically concentrated to make up a majority in the district. Two, the majority group is politically cohesive. This means that the individuals that make up the group vote in a similar pattern. They usually vote for similar candidates. Three, the white majority votes together to defeat the minority preferred candidates. And four, given the totality of the circumstances listed above, the minority group has less opportunity than other members of the electorate to participate in the electoral process and to elect representatives of its choice. So having heard that, can you just give me an analysis real quick on how that analysis might apply, if it does, to the state bill?
Me or the panel?
Whomever.
I'll say my piece and the panel can jump in afterwards. If you look at Baltimore County's council, when they did the map that they did, again, you can look at how our council looks now. We have one black elected official, and that's been the case when we first elected our first black county councilman at the turn of the century. I'm talking just 25 years ago. The current black councilman in Baltimore County is only our second black councilman, 1 out of 7. You look at how the state has drawn its maps, and you look at the representation, I would say in the state, in our state Senate, we have 4 black elected officials in Baltimore County's Senate, 4 out of 8. Baltimore County's population is about 35% black. It's almost split between its white population and its minority population, almost 50-50. I would suggest that our state delegations look more like Baltimore County than what the county council looks like. So that, in an essence, is what it does for me. I think maybe somebody from our panel might want to jump in.
Thank you, Delegate Young. I'm happy to just provide a little bit more information to supplement Senator Sidnor's response on the technicality, if that would be helpful to you. So the legal test that you quoted was established in 1986 by the Supreme Court opinion Thornburg v. Jingles, and that has been the legal test for vote dilution claims under the Federal Voting Rights Act for nearly 40 years. That test has withstood the test of time. It was just reaffirmed by the United States Supreme Court in the 2023 Milligan opinion. But we know that it results in litigation that's costly, that's burdensome, that's complex, that's prolonged, and it is often not the right tool to address the dilution that's occurring. What this bill does is it takes a very similar legal test and very similar elements, but it boils it down to the core elements to streamline litigation, get more predictable outcomes, and reduce costs. So you described first what are called the three preconditions. First, that minority voters can be sufficiently compact in an illustrative district. Second, precondition is that minority voters tend to support the same candidates. And the third precondition is that minority voters are outvoted by a voting bloc. The second and third preconditions together, that's racially polarized voting. So that's the first element in this bill. And the first precondition, that's what's called the benchmark. And this bill provides a more streamlined and flexible benchmark, but it serves the same basic function of requiring plaintiffs, in order to be able to bring a claim forward, requiring plaintiffs to demonstrate that there's an alternative approach that would mitigate the harm that's resulting from racial vote dilution and voters of color being unable to elect candidates of choice. So these elements are drawn from and very similar to the federal VRA, and just like other state VRAs, are designed to make these claims streamlined, more efficient, and more costly.
I really appreciate the thorough answer. Thank you, Madam Chair.
Okay, any further questions? Okay, seeing none, thank you, Senator Sidnor.
Thank you.
Thank you all who testified, and that concludes the hearing for Senate Bill 342, and that concludes our Senate hearings for today. Thanks, folks.